Imagine you're working at a restaurant and you know all of their secret recipes, customer list, and business strategies. Now you leave that job and immediately open a restaurant right next door using the same ideas and strategies. Most companies want to prevent exactly this situation. So when they hire someone, they sometimes include a clause in a contract, which is called as a non-compete clause. A non-compete clause, it basically means after leaving a certain company, an employee agrees not to start a competing business or to work for a competitor for a certain period of time or within a certain area. These clauses, they are very common in employment contracts, startups, businesses, and partnership. Now, here is a very interesting legal question. Can company really stop someone from working elsewhere or starting their own business? Now, well, let's talk about India. In India, this answer is not so simple because the Indian Contract Act, it places strict limits on such restrictions. Let's move further and discuss on the various concepts or various ideas that the Indian interpretation is the right word that the Indian law has on the same. So today we'll discuss this contract. And a non-compete clause is basically a contractual provision that restricts a person, usually an employee, partner, seller of a business, from engaging in a competing business for a certain period of time or in a certain geographical area. Now, before we proceed with this concept, let's first understand what does Section 27 of the Contract Act says. Now, Section 27 of the Contract Act, it reads that every agreement by which an individual is restrained from exercising a lawful profession, trade, or business of any kind is to that extent, it's a void clause. This means that any agreement restraining a person from carrying out a lawful profession or trade, it is generally void. This provision, it also reflects the public policy principle of freedom of trade and profession. Now, unlike many countries like the United States, United Kingdom, where reasonable restraints may be permitted, Indian law takes a very strict approach. However, there is one statutory exception under Section 27. That exception is sale of goodwill. Now, a seller of a goodwill may agree with the buyer to refrain from carrying on a similar business within a specific local limits, provided the restrictions appear reasonable. For example, if a person sells their restaurant along with the goodwill, they may agree not to start another restaurant in the same locality. But the biggest question that arises in employment contract, okay, that is a usually biggest challenge that a lot of people face. Let's talk about non-compete clauses in employment contracts. Now, Indian courts have drawn a very important distinction between restrictions during employment and restrictions after termination of an employment. Now, during an employment, restrictions are generally valid because an employee is expected to act in good faith and not compete with the employer. After termination, restrictions that prevent an employee from working elsewhere after leaving the job are usually considered void under Section 27. Now, this principle has been clarified in several landmark judgments. Today, just for the sake of brevity, we'll discuss about three important judgments. So, the first judgment that we are going to talk about is Niranjan Shankar Golikari versus Century Spinning Mills Manufacturing uh, Limited. It's a 1967 case, AIR 1967, Supreme Court 1098. Now, let's discuss the facts of this case. In this case, the employee was hired for a fixed period of 5 years, which was very common during those times. The employment contract, it contained a clause that prevented the employee from working for competitions during the set term of employment. However, the employee, he left the company before the contract period got over and joined a competing firm. The employer then he approached the court seeking an injunction. Now, the main issue that was to be decided in this particular case is whether a restriction preventing an employee from working with competitors during the period of employment is it void under section 27. Now let's see what the Supreme Court held under this particular case. The court held that the restriction operating during the period of employment is not a restraint of trade because the employee has voluntarily agreed to work exclusively for the employer during that time. Thus, such clauses are valid and enforceable. This case established the principle that the non-compete clause during employment are permissible. Let's talk about another landmark judgment. So when you analyze or read multiple judgments, you get multiple perspective with respect to the same legal concept. That is Superintendent's Company of India versus Krishan Murgai, AIR 1980, Supreme Court 1717. Now, talking about the facts of this case, the employee he had signed a contract that restrained him from carrying on a similar business for 2 years after leaving the company. After leaving the company, now he started a competing business, and the employer argued that the restriction was necessary to protect the confidential business interest. Now, the main issue to be decided in this case was whether post employment non compete clause is enforceable under the Indian law. The Supreme Court held that this clause is void. The ratio in this particular case was the court held that any restriction that operates after termination of an employment is hit by section 27 of the Indian Contract Act, even if the restriction appears to be reasonable. Now, this judgment it reaffirmed that post-employment non-compete clauses are generally unenforceable in India. Let's talk about the third landmark case, that is Percept Demark India Private Limited versus Zahir Khan. This is a comparatively recent judgment. It's a 2006 judgment, 2006 for SEC 227. Uh, Talking about the facts of the case involved a very famous cricketer, Zahir Khan. He had entered into an agreement, a management agreement with Percept Demark, which contained a clause preventing him from entering into any similar agreement with another company for a certain period post termination. Now, later on, Zahir Khan terminated the agreement and entered into a contract with another management company. Percept then approached the court seeking enforcement for a non compete clause. Now, here the issue was that whether such post contractual restrictions were enforceable. Here again, the Supreme Court held that it was void. The court clearly stated that restrictive covenant extending beyond the term of contract is void under Section 27. The court further observed that the Indian law it does not recognize the doctrine of uh, uh, it does not recognize the doctrine of reasonable restraint, unlike the English law. Therefore, post termination non compete clauses are generally unenforceable in India. Uh, let's talk about why these these non compete clauses they may be void. Sometimes the courts have also felt the need to enforce related clauses such as confidentiality clause, non-solicitation clause, and protection of trade secrets. Now, these clauses are very much enforceable because they protect the legitimate business interest rather than restraining the trade. Now, to summarize this particular session, Section 27 of the Indian Contract Act, it declares agreements and restraint of trade to be void. Non-compete clauses during employment are generally valid. Non-compete clauses after termination of employment are usually unenforceable. The statutory exception is only in case of sale of goodwill, and courts, however, may enforce confidentiality and trade secret protections. Now, understanding this distinction is extremely important for law students, lawyers, and startups drafting employment contracts. So while non-compete clauses, they may appear to be very common in contracts, their enforceability in India is significantly limited by Section 27 of the Indian Contract Act and judicial interpretation by the Supreme Court. So if you have any queries with respect to the non-compete clause, do drop it in the comment sections. Thank you, and do subscribe to the channel for more such interesting videos.